This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why the California Court of Appeals slapped down a SLAPP suit and why a lawyer's fraudulent billing is not pre-litigation protected petitioning activity that would support a SLAPP lawsuit. Strategic lawsuits against public participation, SLAPP suits, are meritless lawsuits designed to harass parties for engaging in protected activities, the right of petition or free speech. A party can move to dismiss a SLAPP suit by filing an anti-SLAPP petition. The movant must show the purported SLAPP suit arises from its protected activities, and if shown, the respondent can defeat the motion by showing its lawsuit has merit. In OC Media Tower versus Louis Galuppo, the California Court of Appeals on March 28, 2024, resolved the dispute over the applicability of a SLAPP claim and found that, among other things, a false legal billing is not protected petitioning. Plaza del Sol Real Estate Trust made $67 million in loans to OC Media Tower LP and OCR Land LLC. The loans were secured by deeds of trust and promissory notes in which OC Media agreed to pay Plaza's attorney's fees for any needed collection efforts. OC Media defaulted on its loans, and Plaza agreed to accept a lower payoff amount, about $50.5 million, contingent on OC Media selling its encumbered real estate. During escrow, attorney Galuppo submitted an invoice stating its fees of about $25,000 for its client Plaza. At the close of escrow, Plaza was paid the agreed-upon payoff amount, and Galuppo was paid its stated attorney's fees. Plaza then sued OC Media for fraud and other causes of action. Plaza alleged it learned after the close of escrow that OC Media had made false statements about its real estate sale to induce Plaza to accept less than what it was owed. OC Media filed a cross-complaint against Plaza and Galuppo for fraud and another cause of action. OC Media alleged Galuppo's attorney's fees were false and unsupported. Galuppo filed an anti-SLAPP motion to dismiss OC Media's cross-complaint. Galuppo asserted its invoice stating Plaza's attorney fees was a pre-litigation demand for payment, a protected petitioning activity. The trial court denied Galuppo's anti-SLAPP motion because an allegedly false invoice for payment generally does not constitute petitioning activity under the anti-SLAPP statute. The Court of Appeal, in discussing the issues, noted that an anti-SLAPP motion must be supported and that the trial court was required to distinguish between speech or petitioning activity that is mere evidence related to liability and liability that is based on speech or petitioning activity. The Court of Appeals found that the record does not support Galuppo's assertion that its invoice was a pre-litigation demand for payment. Further, the basis of OC Media's cross-complaint is not that Galuppo made a tortious demand for payment. Rather, OC Media claims the amount of attorney's fees actually billed by Galuppo was fraudulent. Appellants claim the demand for $24,433.08 in attorney's fees was a communication preparatory to and in anticipation of filing litigation. In an anti-SLAPP motion, the movant bears the burden of establishing the challenge claims arise from its protected activity. The essential elements of fraud that give rise to a cause of action for deceit or intentional misrepresentation are 1. Misrepresentation, false representation, concealment, or nondisclosure. 2. Knowledge of falsity or scienter. 3. Intent to defraud, that is, to induce reliance. 4. Actual and justifiable reliance. And 5. Resulting damage. All of those facts existed. The cross-complaint and the anti-SLAPP motion resulted because OC Media and OCR Land LLC sued Plaza, Galuppo, and Morris Cerullo, World Evangelism, for fraud and the common count of money hadn't received. OC Media alleged that prior to the close of escrow, it had asked Galuppo to provide the amount of attorney's fees and costs that Plaza had incurred in connection with the sale of the property at 625 North Main Street. OC Media stated that on October 16, Galuppo transmitted by email a document purporting to be an invoice through which it was represented that Plaza had incurred $24,433.08 in legal fees. OC Media alleged that the invoice was fraudulent. The trial court denied appellant's anti-SLAPP motion to dismiss or strike OC Media's cross-complaint in a written order. Cross-defendants did not demonstrate litigation was genuinely contemplated and was more than a possibility at the time of the invoice amount was communicated. Cross-defendants failed to establish that the cross-complainant's claims or the other challenged portions of the cross-complaint arose from cross-defendants' protected petitioning activity. Mr. Galuppo's subjective intent to file a lawsuit in the event OC Media breached its contractual obligations and obligations was merely theoretical. That is, it was not under serious consideration, and therefore Galuppo's emailing of the invoice to the title insurance company was not protected pre-litigation activity under the anti-SLAPP statute. There are simply no documents from Galuppo or any other attorney representing Plaza directed to HERA, OC Media, or its counsel attempting to resolve outstanding legal disputes. Therefore, the Court of Appeal rejected Galuppo's claim that the invoice was part of an ongoing series of pre-litigation demands communicated to OC Media as part of a lawsuit that was under serious consideration. Actually, it was part of a settlement. OC Media's cross-complaint was not a SLAPP suit, and the judgment was affirmed. Galuppo, in my opinion, attempted to avoid the position of a cross-defendant by filing a SLAPP motion by claiming his bill to his client for the sale of real property was protected petitioning activity. In fact, the Court of Appeals noted that the people suing Galuppo used his billing as evidence of fraud. A false and fraudulent lawyer's bill is not protected activity subject to dismissing what was claimed to be a SLAPP suit. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll have access to the more than 4,750 blog postings. You can also subscribe to the videos at rumble.com or youtube.com, all of which are free. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in greater detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for very small fees subscribing to my Substack publication. Thank you for your attention.